Yeah.
My lord and my lady, I was going to move on to the procedural points that were taken by my learned friend. Can I just remind you of the dates? The hearing before Mr. Morgan was the 7th of November of 2024. And he was going to decide, as we saw yesterday, whether to have the direct that the undertaking be released. For that hearing, Queeld and Meisper served a witness statement of their solicitor, Mr. Leach, of the 7th of October 2024, which you'll find in the supplementary bundle, which I'd ask you to go to if you would, behind tab 21, the first page of which is 292. The reason for going to this, whilst you're finding the pages, is that Mr. Leach was setting out the bankrupt's position in this statement.
292.
Yes, please, and it's 300. 292 is the first page 300, which should find us at paragraph 38 of Mr. Leach's statement.
Yeah.
And for present purposes, about 2/3 of the way through little a, you'll see the sentence, DA's position is that following the expropriation of PSB, he cannot obtain justice in Russia. And they go into that.
So 292 at, sorry, I'm
it's 300, paragraph 38, my lord, at letter A. And he's describing Mr. Anayev's position that his cannot obtain justice in Russia. And if you jump across to 305, the very top of the page, which is paragraph 56A of the statement, again, he sets out, he says, for the reasons detailed below, Mr. Ananyev's position is that his bankruptcy in Russia is politically motivated and he's unable to obtain any justice or due process in Russia. And then he goes into that in great detail. So having set out Mr. Ananyev's position in that statement, we then jump, if I may, within the same bundle to the hearing on the 7th of November before Mr. Morgan, because Mr. Queeld and Meisper's counsel on that day, Mr. Hankey, went into these issues again. And could I ask you to go behind tab 8 on page 117 of the same bundle, a supplementary bundle, which brings us within the transcript of the hearing that day.
Page
117. 117. I hope that's part of the transcript.
Mm-hmm.
Between letters F and G is the beginning of the relevant passage. And this is Mr. Hankey on behalf of Queeld and Meisper spelling out how he thought that there would be a long and complicated route in the recognition proceedings. You'll see at the foot of the page, one can see it's going to require cross-examination, likely live witnesses, require expert evidence, not just Russian law, potentially Cypriot law, potentially BVI law, potentially also experts in relation to Russian legal process and so forth. And then eventually, the judge intervenes between, I'm so sorry.
I understand Russian law. So this is all about just recognition. I understand Russian law. Cypriot and BVI?
Lord, I'm not going to go there. This is what was being submitted. For my purposes, it doesn't matter whether it's what it means. It's what was said, as it were, because we then get down to Judge Morgan, who's been listening, obviously, to these submissions. He then says, are you making those points simply on behalf of your clients? And we, my lord, see that between D and E. And then Mr. Hankey says, so they are my clients. So this is on the basis of my clients now and their understanding of the issues that may be brought to bear. There's an attempt to pursue the recognition application in order to obtain my client's shares from them. These are all arguments. Political persecution of Mr. Ananyev. And then the judge said, these are all points your clients will take, regardless of what Mr. Ananyev says. They're certainly all points that are available to my clients. The public policy, the question of how Mr. Ananyev was bankrupted is fundamental to the question of recognition, of whoever recognition may be sought. So whilst one can well assume the position and the material available between my clients and Mr. Ananyev himself becoming involved are different, it is still an argument that my clients certainly for now would be considering. So at that stage, I do not want to nail my colours to the mast, he said, on exactly what my clients will say in relation to a recognition application. So the judge is saying, well, this all sounds like the sort of thing the bankrupt would say. Is that what you're doing? Are you making submissions on behalf of the bankrupt? And basically, the matter was left up in the air, saying these would be submissions that we could make. And at the end of that hearing, we persuaded the judge to bring forward as my friend Mr. Bayfield described, the return date for the recognition application to the following Friday, the 15th of November. But at the end of the hearing, what also happened is that it was made crystal clear that Queeld and Myspare were not giving instructions to those behind Mr. Hankey to accept service of that, and that they were going to require us to apply to serve out. And they made it clear in correspondence over the next few days that they expected us to make full and frank disclosure to the judge on the 15th of November on the first return date of the recognition application, because they would be absent. And they were, in effect, setting us up. And those are the circumstances in which we came before the judge. And those are the circumstances in which, dutifully, I think, we set out, as we were obliged to do in our skeleton argument, all conceivable arguments which we thought could be run in relation to the entirety of the recognition application. We thought that the bankrupt would oppose. We had a discussion with the judge, and the transcript shows this, that about serving him so as to give him notice. The judge made comments about that's the way in which you would do it under the CBIR, give notice to the bankrupt, but not make him a party. It was made clear that the assistance would be against Queeld and Myspare, if that's where he reached in due course, if we were recognised. But most importantly, we knew that we had to set out every conceivable, seriously arguable point, which had been flagged out up in the hearing a week earlier, as to the sort of points that might be taken against the recognition application generally.
Would you not be required to do that anyway, even if you use the expression set up?
Yes.
But wouldn't you have that obligation in any event?
We did. I think the point I'm making, which probably not very elegantly, is that we thought, we seriously believed that Mr. Ananiev would come to oppose. That's what we thought was going to happen. We thought it was obvious, and we just had to wait. And so we had to go to great lengths to make sure he was served. In fact, on the 18th of December,
Not strictly served, as I understand it, given he received notice.
that he was given notice that he wasn't served as a party, to enable him to decide whether he wanted to join in, as it were. And Judge Briggs felt that that was what would happen under the CBIR in his experience, that on a personal insolvency with a bankrupt, you give them notice, you don't join them. And he said so in his during the day. As it happens, Mr. Ananiev appeared by counsel in some Russian proceedings relating to the bankruptcy on the 18th of December and confirmed openly that he had received the papers and that he was well aware of the recognition application. And there was evidence before Judge Briggs at the hearing in January to that effect, which is why he accepted that he knew about the proceedings. But our fear that he would come into the fray and take all the points did not materialise.
Just out of interest, I mean, sorry, just simple question. Going back, when your application, Mr. Bayfield pointed out that it's a composite application, both for recognition and for assistance. Can you just say why it is that you actually joined Q&M?
We've always said, for assistance, we've always said that, and we'll go to the judge's judgment in a moment, where he recites the times when we say so. We've always said that we want an order against them if we get there, as far as assistance is concerned, and we accept that they have voice.
But on the assistance, you say on the assistance, but not the recognition.
We said so to Mr. Justice Mead, that's in the transcript. We said so in skeleton arguments, and we said so in correspondence. And the judge set all that out in his judgment.
We'll get that, yeah.
You may recall, and for these purposes, it might be, in terms of saving pens, could I invite you to take up our skeleton argument on this appeal, which is at tab 29 of the core bundle, at page 357. 375, I do apologise, page 375. I hope that takes you to paragraphs 36 to 39 of our scope.
Yep.
And where I've reached is paragraph 38, because on the 18th of November, the first accelerated return date of the recognition application, Judge Briggs ordered Queeld and Myspare to file and serve any evidence in response to the recognition application by the 6th of December 2024. And as we say there, by which time they'd been on notice of the bankruptcy order and the appointment for over 2 years. They did not comply with that order. Instead, they served an application to set aside the judge's entire order, as you saw. Now, the relevance of that is that on the 28th of November, the application which is referred to in the fourth line there was indeed served on the 9th of December. It was actually issued, and we saw it in draft, on the, I think it was the 28th of November. And that's the application you saw earlier. My Lord Justice Snowden was asking what was the evidence in support of that application. Now, that application was the first time that we appreciated that it looked at least, one, that the bankrupt was not going to participate, and secondly, that Queeld and Myspare, having not nailed their colours to the mast before Mr. Morgan, were now nailing their colours to the mast, and they were taking a root and branch attack on the whole concept of whether my client should be recognised at all.
But just to retreat, can I ask you the same question? That your evidence in support of what has been termed the recognition application, which in fact, as we know, includes 2 paragraphs. One is recognition, 2 is assistance. Has your evidence always been solely directed at the recognition part, or in part directed at assistance?
The answer is recognition. We did not think that assistance would be dealt with in terms of paragraphs 2A or 2B at the hearing before Judge Briggs, and nor did Judge Briggs.
Oh, okay, so the evidence in support of the application at the start,
Yes.
was served with it,
Yes.
or at any subsequent time, you say did not include any evidence in support of assistance.
Oh no, I'm not saying that, because necessarily the whole story was told by both the trustee and Mr. Beckwith, the solicitor, as to, so the evidence was in support of both. Sorry.
So you did put in the evidence that would have justified the grant of some sort of assistance.
Sorry.
We were taking some of those witness
Yes.
statements.
We were. There were 2 statements. The one I think you barely saw, which was from the trustee himself, and the other was from Mr. Beckwith.
And we were only taking little bits of that, was all.
Yes, they tell the whole story. And one of the things that comes out of Mr. Vesnin's statement is that there was a genuine, tangible fear that Mr. Ananiev himself would become involved, because, as Mr. Vesnin described in his witness statements, he has so much money at his disposal, he could probably just stifle us anyway. I think $1 billion was taken out the day before the bank went into administration and went into his companies and pockets. And the idea of having to litigate against him was of great concern. And so we were, in the evidence, setting out pretty much the whole story as we knew it to explain why we wanted both recognition and assistance. Now, I reached the stage where the application was issued but not served until the 9th of December. And that was the application to set aside Judge Briggs' order and seeking to challenge that paragraph of relief to 2A in the recognition application and for security for costs and so forth. Could I now ask you to turn to the judge's judgment, which is in the core bundle at tab 23-298. That is Judge Briggs' judgment, which is under appeal on this appeal. It's page 303 behind tab 23. I hope brings us to paragraphs 22 onwards of his judgment. And at 22, he says Mr. Vesnin named Q&M as respondents because the assistants sought in paragraph 2 of the draft order specifically referred to them. Mr. Vesnin says he did not anticipate Q&M would seek to oppose the first prayer, that's common law recognition. I should emphasise we did expect Mr. Anied to do so. This may explain why neither the skeleton argument for Mr. Morgan nor his skeleton argument made reference to them seeking to oppose recognition and instead focused on Mr. Ananiev's submission to the jurisdiction in the Moscow Bankruptcy Court. Mr. Vesnin says that the first time he heard that Q&M's formal opposition was, of their formal opposition was when the companies made their application to set aside the expedited directions and issued the jurisdiction challenge on the 26th of November. And it's that which caused us to eventually, what happened was once again, Q&M managed to get themselves into the interims list. And it was, if I may say so, poor Miss Justice Mead who had to grapple with the whole history on an interim application. And it came before him on the 18th of December. And our skeleton argument, insofar as relevant, is recited there by the judge at paragraph 25.
Page.
Page
Sorry, that's your skeleton before Mr. Justice Mead cited at paragraph 25 of the judge's judgment under appeal.
Yes.
Yeah.
And we said this, ultimately, if the respondents are to persist in their position, they are not nominees for Mr. Ananiev and his associates, and they will need to persuade the court they have a legitimate interest to resist the applicant's recognition in this jurisdiction, as opposed to resisting any relief to be granted following recognition. They are strangers to the bankruptcy and have no stake in it. And then during the hearing, paragraph 26, I submitted that they cannot have their cake and eat it. If they are strangers to the bankruptcy, the recognition is neither here nor there. All they are interested in, or should be interested in, is relief or assistance if recognition is granted. And that was on the footing that Mr. Ananiev has basically decided not to oppose recognition. And then the judge faithfully sets out in the following paragraphs how we took again and again, paragraph 27, 28, 29, the point on standing.
Well, is this a point on standing? It's asking why, I mean, so for example, 27, why they are intent, why are they doing it? Similarly in 28 and 29.
Yes, my lady.
It's not, and I understand the relevance of these paragraphs, but they're not, they don't jump off the page as being, you cannot be heard, the court cannot hear you.
Well, my lady was saying, what legitimate interest do you have? I mean, we're talking to sophisticated lawyers here, and we're saying you're strangers to the bankruptcy.
That's the skeleton before Mr. Justice Mead.
Yes, and when they were represented by solicitors and counsel. And at the hearing, we said the same thing. Recognition is neither here nor there. All they are interested in, or should be interested in, is the relief or assistance if recognition is granted. And then over the page, they failed to explain why they even intent on opposing recognition when their cases they are strangers.
Why doesn't it simply say they don't have standing?
That is...
Because that's the issue now.
My lord, it is.
And it's a very odd way of putting it.
Well,
Fail to explain why they're even intent on opposing recognition.
It is the nomenclatural language in this sphere. When one talks about someone being a stranger to the bankruptcy, it does mean, it's shorthand for saying you've got no standing.
What do you say in the skeleton argument for the hearing before ICC Judge Briggs?
I don't think we referred to standing there because by then we were operating on the basis that Mr. Justice Mead had made his direction.
Indeed.
And we had to be, you know, that's what he had directed should happen. It was the judge who said, well, he had an obligation to satisfy himself whether they had standing.
Can we just remind, for my benefit, just remind ourselves what those 4 issues were again? I know the first one was during 2A, and the security for costs.
Yes.
Tab 37. Supplemental tab 37. Tab 37, 507.
I think it's tab 37,
In the supplementary.
supplementary 2. So
Yes, thank
page
you.
507, I think.
Then there was we had a pending application for an injunction.
Oh, that was in the Eurasia proceedings, wasn't it?
Well, yes, it hadn't actually been issued at that stage, I don't think. But the idea was that if this court did not grant a stay pending this appeal,
Yeah, yeah.
we needed the injunction. And that was just some incidental costs. But I think it's possibly the cost of the Mead hearing.
So those were the 4 issues that Mr. Justice Mead identified.
Yes.
So
Yes.
you were referring to that as an answer as to why you didn't refer to standing?
Well, my response to standing is that we have flagged up they were strangers to the bankruptcy. Mr. Justice Mead had taken recognition, as it were, off the table for the hearing in January, and to use the judge's word, he had repurposed the hearing so as to determine that the 4 issues listed in his order.
And so standing was irrelevant, or for another day, or what?
Well, we at all times made it clear that we didn't consider they had standing, and in fact the judge found that in his cost judgment.
Well, no, I understand that, but what happened to it, or what was thought to have happened to it, following the order of Mr. Justice Mead, that these were the 4 matters to be dealt with in a 2-day hearing in January?
Well, it was still a live issue. That's all I can say, is that
It was a live issue. How? If it had been repurposed and it was going to be these 4 things, standing wasn't something that was going to be considered or prepared for. I thought you said in answer to my lady's question that you didn't deal with it in the skeleton.
That's right.
Because the hearing had been repurposed.
Exactly.
So it was on the back burner.
It was a point that would have to be argued out at some stage.
So, if you like, these are sort of 4 not really preliminary issues, but 4 issues to be heard per Mr. Justice Mead's directions before you got on to the substantive.
He was persuaded to make those orders.
Well, yes, he was persuaded. You're stuck with that order. That is the order he made.
Exactly. Exactly. So, I mean, we had made it clear that we thought that they didn't have standing on
Yes,
recognition.
but that order remained in place.
Yes, we didn't appeal against that, no. So we and it was in those. It may be just worth taking you very briefly within the core bundle to page 292, which is within the judge's cost bundle, cost judgment. I mentioned that saying someone is a stranger is just the language that's used in this context, and at paragraph paragraph 41, the judge summarised again what we'd said in our skeleton argument about standing. And then at 42, he said they are strangers to the bankruptcy. They have no stake in it. This put Q&M on clear notice that there was an issue about standing. The issue was raised again before Mr. Justice Mead at the hearing. It was said that Q&M can't have their cake and eat it. If they're strangers to the bankruptcy, the recognition is neither here nor there. All they are interested in is the issue of assistance because that may affect them. This is the point at which
People
Q&M...
keep telling them what they're interested in. It's a very odd way of going about things, said the common lawyer. Why do people keep saying what they're interested in? It's for them to say what they're interested in. They keep telling us what they're interested in. I don't understand why other people are telling us what they're interested in. That I mean, it's very odd. It's not, none of it's direct. Because standing ended up being the repurposing of the repurposed hearing when the judge bounced in on the first day and said, you haven't got any standing.
Yes, because the point he was making is that he's bound to take a point as to, do you have standing to make submissions to me on a recognition application? What is your standing?
Yeah.
And he
And
did
I would
that.
have thought that would have been the first point dealt with in the skeleton arguments before the hearing.
Well, perhaps we showed undue deference to Mr. Justice Mead. I mean, that's
If
what
you
we did.
didn't think they had standing, then that was the first point on the batting order, surely.
Well, we certainly were taking the point on standing throughout, but we did honour Mr. Justice Mead's directions, and we took him to have repurposed the hearing.
As you say, you clearly don't agree with Mr. Justice Mead's hearing
No.
directions. They were interim directions. They certainly didn't shut you out from all of them. You can't sensibly argue that they.
Well, the time estimate and everything else was on the footing of those 4 points. We were maintaining that when it came to it, there would be no standing, but they wanted to apply to strike out part of the recognition application in respect of which they did have standing, 2A. That was all their strikeout went to. And
that was the jurisdiction point.
yes,
So the plan was to deal with a bit of standing and leave the main standing point for another day.
no, the 2A point was not a standing point at all. It was suggested that you under permission to serve out should not have been granted in relation to 2A. That was the point that was
I
being
can
made.
see in a way that that's discreet, but the other
Security for costs.
security for costs and costs of the timetable application, they're inextricably bound up with the recognition, aren't they?
Well, as far as we were concerned, having got recognition, there may well have been a long period before we were granted assistance because we had to accept that Queeld and MySpare were allowed to be heard on assistance. And they wanted security for costs in that respect. It's perhaps worth reflecting. Our position was we wanted to participate in the underlying proceedings for which we wanted recognition. That was urgent, and that was so that we could, in effect, serve a defence in those proceedings, as we've now done, and get on in those proceedings.
So, just going back to how my Lord's question about what happened to the main recognition application, are there any directions in Mr. Justice Mead's order for the hearing of the main recognition application?
No.
So was it
That was in the long
effectively
grass.
assumed that that would be dealt with during one of these hearings?
It was going to be, yes, after, because yes, I'm reminded he formally vacated the final hearing of the recognition application,
Yes, on
but
paragraph 2.
did not make any
Okay, so
residual,
it
as
wasn't
it were.
relisted.
So sorry.
So I hesitate to rise. Can I just make one point that's relevant to my Lady Justice Falk's question about security for costs? The security for costs application was made not only in relation to the assistance part of the recognition application, but the whole of the recognition application, including paragraph 1. So when my lady says, well, isn't standing wrapped up with security for costs? The answer is yes.
Sorry, so you sought the application for security. You sought security.
My client sought security for costs in relation to the recognition application, both parts of it.
And did that get resolved?
That was dismissed by the same order that you saw that dealt with costs and the dismissals of the jurisdiction challenge. It was never argued, but because we were found to have had no standing, the security for costs application was deemed by the judge to have fallen away.
Okay, so where do we go now?
And so when therefore at the hearing, the judge raises standing and says that he wants answers, he, as he recites in his judgment, over the day, it was a day, asked for an explanation as to what it was that Queeld and Maisper were pointing to as giving them a legitimate interest to oppose recognition. As he recites, he did not get a response to that which was satisfactory. And he did fairly put to them what he saw to be the three categories, which you saw earlier, of persons who might have standing. And the matter was then left at the end of day one. And overnight, nothing was forthcoming from the Queeld and Maisper in response to those questions. And the judge picked the point up again on the second day. And it was during those exchanges that my own friend, Mr. Edwards, was referring to the Brake decision, and reference was made also to another decision. And the discussion was made along the lines of strangers not having interests. And then the judge basically concluded that he could not see that the position would be any different in respect of a recognition application than in respect of an ordinary bankruptcy hearing in this country. In other words, if Mr. Ananyev, if you change the facts, if a bankruptcy petition were presented against Mr. Ananyev in this country, Queeld and Maisper would not have standing to come to court and say that the underlying judgment creditor's debt was, for instance, procured by fraud. It's not something that the court will listen to from a stranger to the estate. That being the position in England, and it undoubtedly is the position in England, it shouldn't be any difference if, in fact, what's being asked for is recognition of a foreign judgment. The same people can have standing. That has no bearing at all on the question of any assistance which might later be requested based on that recognition.
Sorry, can I just unpick that? Sorry, I was not really keeping up with it. You're saying if in this jurisdiction a creditor brings a bankruptcy petition
Yes.
against a debtor,
Yes.
that somebody who might fear that they would be pursued by a trustee in bankruptcy has no standing to appear on the petition.
Yes.
Is that the point?
It is.
I misunderstood.
No. I would respectfully submit absolutely no standing.
Right.
And going back to those examples in our skeleton argument, if in any of those examples, the person who would have a very real, in a populist sense, complaint and concern about the bankruptcy would want to stop the bankruptcy, but wouldn't have any legitimate interest in doing so, not that would be recognised by the court. And it's the same here. Queeld and Maisper have no legitimate interest in attacking this foreign bankruptcy order. That's the only issue. They're in no better position than if the position were in England.
So just to run this through. Structurally, on the hearing of a bankruptcy petition, creditors can appear, but not debtors. Not people who owe money to the.
Oh, I see.
bankrupt.
Yes, not in debtors in the sense of the putative bankrupt. Yes.
The person who owes money, he's a debtor who's going to be made bankrupt,
Oh,
obviously
yes.
can appear to say, I shouldn't be made bankrupt. Creditors can appear to say, either I support or oppose the bankruptcy,
Yes.
because their creditors and would be interested in the estate, or would be interested in the effect that the bankruptcy might have on their own claims, let's say.
Indeed.
But you say the one set of people who couldn't appear are debtors,
Absolutely.
people who owe money to, or alleged to owe money to the bankrupt.
That would revolutionise the bankruptcy court.
Even that, so they've got no say in who will pursue the cause of action against them, whether it should be left to the bankrupt or his trustee.
Which takes us full circle to those examples, which is the same but with a foreign element. Exactly the same point. Which is why it mattered so much to us whether or not Mr. Anania was going to put his head above the parapet, as we had thought he would, as a result of what was said to Mr. Justice, to Mr. Morgan. But the moment it became clear that it was only Queeld and my spare, then we thought, and I make no apologies for this, and we thought naively that we could say that you're just a stranger on recognition. Totally accept. Obviously, we joined you because we want assistance against you, but you've got no say in this. You've got no interest that the court will recognise to be concerned about whether this bankruptcy order was good or otherwise. Totally different had it been Mr. Anania.
So the point was made against you that if you're said to be a debtor to somebody, and you are pursued in relation to the debt by a third party, you have an interest in presumably understanding or contesting that they are entitled to pursue you for the debt. How has the debt that you owed to Mr. A been transmitted in some way to Mr. B, who's now suing you claiming the debt?
Yes, well, that's just a private transaction, an assignment, and obviously you have to prove your assignment. I mean, that's fine. You can't. You want to make sure you're not going to be sued by somebody else, as it were.
So
the assignor might still say that the assignment, the assignment has to be proved, but with the statutory assignment represented by the bankruptcy order, that's a wholly different ballpark.
well, but isn't it saying whether the English court should recognise what is in effect the statutory assignment of debts pursuant to the Russian bankruptcy code?
What I mean is this.
Why shouldn't a debtor be in the point that's put against you? I'm just putting
Yes.
the point to you in a way that I can understand as sort of simplicity.
Yeah.
It said, well, why shouldn't the debtor be entitled to have a say and put to proof the person who it is said is going to be pursuing them for the debt?
And the glib answer is the same as Lord Richard's answer in all the cases he went through in Brake, as to why they certainly have commercial interests and they certainly have all sorts of interests, but they don't have legitimate interests from a bankruptcy point of view.
There's one case we haven't looked at yet in any detail at all.
Well, it's summarised by the judge, and perhaps we're being a bit that's sort of unforgivable shorthand. But the judge has taken out in his judgment the kernel of it and the ratio.
So we don't need to look at it.
And it is that there are you can have technical standing, but you still need to have a legitimate interest.
Because in the judge's judgment, it's what does appear to have come before the judge's consideration of his own earlier decision,
Yes.
Mr. Bayfield says was the right one, as opposed to the path which the judge followed. And you say, yes, he was right to disregard his own earlier decision because he had Brake in front of him.
Yeah, all we say, and no more, is that there is a 2.5 or perhaps 3 centuries of jurisprudence to the effect that strangers to a bankruptcy cannot, whether it's oppose a bankruptcy order, apply to modify the actions of a trustee, or otherwise interfere with the administration of the estate. That's just recognised English jurisprudence. And all the judge did was apply that to a foreign recognition order.
Is it a distinction that Brake is concerned about challenges to acts of a liquidator or a trustee, as opposed to the status of them?
Well, I don't know of a case in our jurisdiction or in the Commonwealth of the last 250 years where a stranger has been allowed to attack the appointment of a trustee.
But is there any case where the stranger was joined by the person who now says they don't have standing?
Well, there wouldn't be, because, of course, we did join them for a good reason, which was assistance.
So there isn't?
No, certainly, because they're... yeah, I don't think there would be.
You also mentioned you don't know, I think you said, in response to the point that Brake concerns challenges to acts rather than status. Are there, apart from the Sturgeon case to which we've been taken, are there cases which go to status, where some third party attempted to challenge and were told they were?
I don't think so, and I think I can give a reason why, I think. Staying with bankruptcy and staying in England, there have always been strict rules as to who may appear on a bankruptcy petition.
Yeah.
And they are the persons we've been, or categories of persons we've been talking about. And that's for very good reason. And they're for the very reasons that were set out in Brake, in terms of having a legitimate interest in the order which the court is being asked to make. And going back to the debtors, I do submit that a debtor simply has no standing to oppose a bankruptcy order. And one of the reasons for that can be perhaps easily seen. If there are complaints about the bankruptcy order itself, the debtor can always ask creditors to support him. He can always find someone who does have standing, and that happens. But if no creditors are complaining, then the court will not listen, because the process is for them. There is an added dimension, I accept, in personal insolvency, because there's also the bankrupt. The company obviously doesn't have a separate, it's not a human being, but the bankrupt is. And the bankrupt in both domestic and foreign insolvencies might have an interest of his own, and Lord Richards goes into some of those. To take an anodyne example, his tools and various personal items are not, they don't form part of the statutory vesting of the bankruptcy estate, and there may be a dispute about that. There may be all sorts of things. But ignoring the bankrupt for these purposes, it's the creditors.
Can I, just while we're on it, paragraph 35 of the judge's judgment, the 3 categories, you're really focusing on category 2. Category 2, bankrupt and creditor. Yes, you say they have an interest. Who's in category 3? Is there anyone else?
Well, it's hard, of course, we're
It
here
may
with,
not matter, but
No.
I mean, this is really from my own understanding.
in term, if one thinks in terms of global bankruptcies here,
Yeah.
there's bound to be a category 3 because one is not to know the systems around the world as to what systems might give persons an interest in the foreign bankruptcy.
I see. So yes,
It could be anywhere, Hong Kong, and so forth.
Okay, so you say it's leaving the door open.
Yes, it's a residual category.
So, I mean, for example, if a foreign bankruptcy statute required money to be paid to the government.
There's a good example, yes.
I mean, it's not as creditor. that
No,
is,
exactly, that kind of thing.
if there's some levy on bankrupt estate.
And in fact, one can go all the way back to Article 25 and remember that list. And there are some categories of persons in there that would not fall into category 2,
Thank you.
which are public bodies and so forth. One simply can't be that prescriptive because we're talking about global possibilities.
Yeah, thank you.
I mean, it could be a landlord. I mean, the example everybody always goes to is landlords.
Hans Plass.
In a sense, landlords are at least prospective or contingent creditors generally,
Yes.
but landlords may have a different interest adverse to the estate.
T&N, asbestos future creditors, which may not be creditors in a foreign jurisdiction. I don't know. That kind of person is hard to, until one has the case, one doesn't know. But they're all, one way or another, interested in the bankruptcy in the real sense. And so, in summary, we don't suggest for a moment that either the judge's disposition or, in a sense, more importantly, his reasoning is at all offensive in terms of conventional jurisprudence. He was saying no more than, I cannot understand how you are to be permitted to challenge this man's status. I totally understand how in due course you might want to resist him being given assistance by this court. And in effect he was saying, I'm not allowing the court to have a 5-day hearing with expert evidence from all sorts of jurisdictions in order for someone with no legitimate interest to try to challenge the status of this trustee or the bankruptcy order. And in fact, if you stay with his judgment and look to I think there's almost the ratio really in this respect is paragraphs 45 and 46. 47 just deals with the facts. (45) is his definition or decision as to who does have an interest to oppose recognition. And he equates the English position then with the foreign position because of the universal nature of bankruptcy. That's the first sentence of paragraph 46. And then he says, such persons will include creditors, but not a party who is a defendant in proceedings where a foreign representative seeks to be a claimant, or the other way around. I accept that such a person will have a commercial interest in the outcome, but have no legitimate interest in the bankruptcy. Then on the facts, he found that Queeld and Meisberg accepted that they could not make out any legitimate interest other than they wished to frustrate Mr. Vesnin's attempt to challenge ownership to the shares within the Eurasia proceedings, which appears contrary to their agreement with Eurasia. And then on that basis, he found they had no standing to oppose recognition.
The words all the other way around, I hadn't focused on that. What's he thinking about?
You might be
there?
wrong about that.
Yeah, I was just thinking.
If they're a creditor, then if and insofar as those words would make them into a creditor, it depends. But I accept, and I must accept, and will always accept, that the creditor against Mr. Ananiev has standing.
So if you are making a claim against a person, and suddenly a foreign representative pops up saying, I now stand in the shoes of this defendant, you'd accept that the person who's bringing the claim would have the right to oppose recognition of the foreign person claiming to be the foreign representative and say, hang on a second, I'm not suing you, I'm entitled to sue Mr. X.
It's OGX in one sense, because it's the arbitration. The company's being sued by a creditor. It's the same. That's why in OGX the creditor had standing.
In order to say, don't recognise this foreign insolvency or anything to do with it.
I have a claim.
I have a claim against him or that company.
Absolutely.
Individually. You shouldn't recognise that they've been replaced by somebody else.
And that brings us full circle. If I could ask you to come back. Sorry.
The words in brackets may not be right.
It might not be right in all cases. I can't say what he had in mind. But it's not our case.
Are we leaving the judgment?
We are, my lord. I'd like to go.
If we are, can I just ask you one thing? In the submissions a moment ago, when you were saying that neither the disposal nor the reasoning was offensive to conventional jurisprudence because it was conventional as an approach to recognition, and that was distinct from assistance.
Yes.
But the judge went on to deal with assistance.
Yes, he did.
Even though Q&M weren't there.
Well, thank you for raising that, because I want to address this point, if I may.
Please do.
I'm sorry, I had it slip my mind. Once the judge had indicated that he had made up his mind that Q&M had no standing vis-a-vis recognition, my own friend Mr. Edwards invited the judge to direct that they cease to be parties. The judge's response, this is all in the transcript, was to the effect that it wasn't for the judge to direct, it was for them, if they were so advised, to decide whether they wished to apply to cease to be parties, because of course we were making it clear that they were also we were moving on to assistance, and albeit very, very limited assistance, and that they were parties for that purpose. What then happened is that the judge was invited to rise for a short time whilst my learned friend took instructions. When we came back into court, my learned friend made an application to be removed as a party, both in respect of both, necessarily, recognition and assistance. He made that application under 19, whatever it is, 5 of the CPR, and it was debated and acceded to, and then he left court in the knowledge that the judge was then going to go on to deal with recognition and assistance.
Sorry, he hadn't formally dealt with recognition at that
No, he
stage.
hadn't.
He'd
Dealt with standing.
He'd indicated,
He had.
and then presumably he gave his initially extempore judgment after that.
Yes, I think that's right. I can't actually remember whether he must have done, I think.
Did you resist that? Did you resist that on the basis of actually, they don't have standing on recognition, but they shouldn't be allowed to withdraw in relation to assistance because we got permission to serve out. Sorry, why did you allow? Sorry, they asked to be removed from the
Completely,
application
yes.
completely.
Yes.
You say, yeah, okay, they've got no standing to resist the recognition application.
Yes.
But what about assistance?
Well, at that stage, all we wanted was to participate in the Eurasia proceedings. That was the only assistance that we wanted at that stage. And that's all we asked for. And we were agnostic as to whether they were a party to that or not. It was a matter for them. If they elected to remove themselves from court, then so be it.
Sorry, just to add another complication to the mix, weren't the BL proceedings, i.e. the Eurasia proceedings, in front of
They were.
the judge?
They were.
So which proceedings did,
Only the recognition
okay,
proceedings.
so in theory they could have come in, well, depends whether you thought you were asking for assistance in the BR proceedings.
No, we were not, no.
Or whether you were asking for them in the Eurasia proceedings.
We only asked for assistance in the recognition and assistance proceedings, and the only assistance we asked for was that we, in effect, the limitation on the order in the Mead order, the Johnson order, I'm sorry, be removed so that we could fully participate.
But in the end, the judge made orders, insofar as he granted assistance, there were orders in both proceedings because we've been taken
Yes.
to them.
Yeah.
He joined you
No, we were joined already. We were already a party.
to the Eurasia proceeding.
Yes. We were made a party back all the way back on the 13th of March.
So paragraph 93 of the judgment's wrong then, is it?
Let me just, I can't remember how to put it.
No, I think it's for the purpose of making a claim. They were joined on a limited basis.
I've lost the judgment. 93.
322.
Yes, it's not. It's shorthand. I mean, it was clear that we were parties. It was clear that we wanted the restriction removed so that we could fully participate, and that's what.
That's assistance, isn't it?
Yes.
It's under the heading of assistance. Why did you oppose them withdrawing from that sort of issue?
No, not at all, my lord. No, we were more than happy just to get a green light so that we could participate in those proceedings. So it's a matter for them if they wanted to withdraw. That's not my problem, as it were. I mean, they elected not to stay in court for the assistance application, and they wanted to cease to be a party.
No, it's just curious. Sorry, I'm just trying to get my head around this. You joined them in the first place to the application seeking both recognition and
Yes.
assistance.
Yeah.
You then said the judge is right to refuse to hear them on the recognition part,
Yes.
and you don't care whether they are in fact there for the assistance part.
Well, at that stage, of course,
So I'm just struggling to get my head
Yes.
around this.
where we had reached at that stage was that we were going to join fully the Eurasia proceedings, and that was it. And we wanted to just plead our case to Eurasia proceedings. Forget paragraph 2A or B of the recognition application. We wanted simply to participate and to object to the release of the undertakings, and that's where we reached. And that's where matters are. We've now pleaded our case out, and they've pleaded a reply, and we've got a CMC coming up.
So that's sort of overtaken de facto
Yes.
paragraphs 2A and B.
And all we want now is for those pleadings to end up with a contested hearing. And the court will decide whether or not to uphold our objection to the release of the undertaking.
Although those paragraphs go further, as we saw yesterday.
Well, we reserve the right, obviously, clearly, and it may well be that.
So right, you're actually asking the court to make an order that you be delivered the share certificates.
Oh, I see. I'm sorry. I thought you meant in terms of assistance. I was still addressing this idea that we didn't object to the application or
Yeah, okay.
contest the application. Sorry, that was a very long-winded response to a question, I think. I'm sorry for that. Can I therefore come back to our skeleton argument, if I may, and just in the light of those submissions, just remind you what we say at paragraphs 13 to 15. My friend Mr. Bayfield has now dropped the suggestion that a bankruptcy order is made against somebody, so we can ignore the sui generis points made in paragraph 13. But paragraphs 14 and 15, could I just, this is in response to my Lord Justice Snowden's point about being a defendant or a claimant. As identified by the authors of Sheldon, a foreign bankruptcy or a liquidation order is different from a foreign judgment. It affects the rights of third parties with claims against the insolvent. It would be quite wrong to apply the rules of recognition. And then we quote from Sheldon, but I just invite you to read that. And just to finalise this point about being a defendant or a claimant in those examples, in summary, the effect of a bankruptcy order is that it's not made against anyone. It affects the rights of third parties against the bankrupt.
It's made against the bankrupt.
Yes.
It's made against the bankrupt, right? You're not saying a bankruptcy order isn't made against the bankrupt.
Well, Lords Hoffman and Lord Collins say it's not made against anyone in the sense of recognition of foreign judgments. In that context, it's not treated as made against anyone. It's made in respect of the bankrupt's estate, and it vests his estate in the trustee.
If I was a bankrupt, I would rather think that taking my property away and
I agree.
Somebody else is an order
accept
against me. I think I struggle to think that wasn't an order against me, but maybe I'm just wrong in that. But
a bankruptcy order has been made against.
a bit sensitive, I think, maybe, but yeah.
So the point, though, is in relation to third parties, and it's the rights of third parties against the bankrupt which are relevant. And going back to those examples of persons who are being sued by the bankrupt, they don't have any recognisable rights in this context. And what we attempt to do in paragraph 17 onwards is to explain jurisprudentially why it is satisfactory and why it is coherent for the judge to apply the English rules on standing to recognition. And you start by reminding ourselves that the idea in all of this is that there is, with exceptions of course, one universal bankruptcy process. And what we suggest is in paragraph 20 that there's no principal basis for giving outsiders greater rights just because a bankruptcy order is in a foreign jurisdiction. The standing rules should be the same for both.
And is this right? You say we shouldn't be troubled by the fact that defendants to potential proceedings by foreign trustees can't raise public policy concerns about the making of the bankruptcy order in the foreign court, because it's always open to the bankrupt to come to court to do so,
And any creditor.
or indeed any other creditors.
And in fact, they might employ someone who does have an interest and get them interested and come along, but they just can't, as passers-by in the street, do it. Legal passers-by in the street. And that's why bankruptcy is sui generis. It's special. And I hope I'm allowed to say this. Of course, as the chief bankruptcy and insolvency judge, the judge will be aware of the sort of delineation here because they jealously protect those whom they are bound to protect in the insolvency court and are very aware of those who really are just busybodies and shouldn't be there in a legal sense. And I would respectfully suggest that he got it absolutely right. As a matter of law. And moving on from that, could I just ask you to look at paragraph 24 of our skeleton? I think there's an important point I'd like to just emphasise here. We have said there is a bright line as a matter of legal principle between recognition on the one hand and assistance on the other. And it is in the world of assistance, this is 24b, where the courts, including recently Lord Richards in the Begemov in the Supreme Court, agreeing with Lord Sumption in Singularis, have recognised that modified universalism, as we now call it, remains an important element of the common law as regards assistance in cross-border insolvencies. So it's necessarily subject to local law and local public policy. Now that is where all the flex is. As we say, the court must at that stage have regard to a range of considerations when assessing whether to grant assistance, and if so, for what purpose and by what method.
Do I understand you correctly, though, that the range of considerations that you say the court could have regard to at that stage would not include public policy issues in relation to recognition?
Well,
unless raised by the bankrupt creditor.
That is not something that you have to decide, in the sense that it might depend on the facts, but I can well see how, for the purposes of assistance, somebody who is otherwise a stranger would be entitled to take all of those points. I can well see that.
But if that's so, then the court's on notice at the recognition stage, as it may well be due to the duty of full and fault disclosure, if the court's on notice that points of that nature might be taken, why in effect is the court forced to leave that matter for the assistance stage?
It's for the same, sorry.
That's really what you're saying, isn't it?
For the same reason that that's what happens or should happen under the CBIR. And that's what the editors of Sealy are getting at. That at the threshold, it really should be quick and efficient. But that doesn't shut, sorry.
That's not what Mrs. Justice Rose was saying.
Well, Mrs. Justice Rose was looking at it, as I was about to say, after the event. She did, I entirely accept that she posited what might have happened at the ex parte hearing. But that was an application that was made after the event, looking back at the order the court had made and asking whether the English court should have made that order. Our point is that according to the foreign trustee, recognition of his status and authority to step in the shoes of the bankrupt is something that should be done quickly, easily, and efficiently. This case is a perfect example. He should be allowed to participate in the Eurasia proceedings without a year's gap when he's got to defend a suggestion that there's political motivations in Russia.
Even if ultimately, just to make sure I do understand what you're saying, even if ultimately he might face an argument which the court might permit at the assistance stage on your case, that there were very strong public policy reasons not to recognise in the first place.
And yes, is the answer, because from his point of view...
And then what's the consequence? Set aside the recognition or just not grant the assistance?
Just not grant the assistance.
So the
You make the
recognition
court might
stays in place.
I'm sorry?
The recognition stays in place.
Well, it may or may not. I mean, it does depend on the facts. But one thing's for clear is that in the meantime, he's been allowed to participate. And if it's at risk that in the future the court might decide for some reason to set aside the recognition, that's a risk he's prepared to take. He's always at risk that Mr. Ananyev will come out of the woodwork and make an application to set aside the recognition order. It's just something he has to live with. The fundamental complaint that we have is that the law should not allow, any more than it should of the bankruptcy order in England, the bankruptcy petition process to be wrecked by someone with no interest in the bankruptcy.
I'm just getting confused, this is just me, why you're saying it's being wrecked, because the only reason really you've come to this jurisdiction, it's obvious, you really want to secure those replacement share certificates. That's what you want. The effect of your argument appears to be not to rule out these so-called wrecking arguments being raised at some stage in the process of the very thing you want to achieve.
Well, forgive me, I think from my point of view, I'm saying I don't know ultimately what the answer is to that second question because it's not relevant on this appeal.
Okay, so you say we don't need to go there.
We don't need to go there.
Well, you say we don't need to go there, but for myself at least, I think it
I mean,
might be relevant.
we would be saying at all times that they cannot raise this. But it's not an argument that's live on this appeal. We would always say for the same reasons.
I mean, your example of, I understand your example which says, look, first of all, just postulate a domestic bankruptcy petition and ask the question, could somebody who owes money to the bankrupt, or the alleged bankrupt, rock up to the court on the hearing of the bankruptcy petition and say either I don't think you should make an order or you should make an order because he's got no standing, you'd say, to effectively have any say in who pursues the cause of action against him, whether it's the individual or a trustee in bankruptcy. And you could sort of understand why that might be, but there might be all sorts of reasons why somebody who owes money to a bankrupt might much prefer to not see a well-resourced trustee, for example, in the saddle. Because it's got nothing to do with him, he owes money to the estate, he's not a beneficiary of it. And you say, well, it should be the same if you've got an international bankruptcy. What happens if on the international plane? I mean, you've got where the recognition could turn on other questions, such as there could be more than bankruptcy. I mean, in other words, we're looking at a singular bankruptcy abroad. It is perfectly possible, and indeed there are cases where somebody has been made bankrupt in more than one foreign jurisdiction.
I see, yes.
And in other words, he was domiciled in one place, but he'd submitted to the jurisdiction in another abroad, and he's been made bankrupt in both places. And then there's actually a competition in this jurisdiction as to who should be recognised. Now, I'm just trying to follow this through how it works. When the question of recognition arises, do you say that the English court would say, well, we'd recognise each of the foreign bankruptcies for what they are, but we'd only grant assistance to one of them in terms of allowing them to pursue a claim in this jurisdiction? Is that the way it works?
Well, I mean, it would depend on the facts. It really would depend.
At what stage do you accept, because this was my lady's question to you, at what stage would you accept that it was appropriate for the defendant to these proposed proceedings to come in and have a say in circumstances where it could matter to the defendant genuinely whether, in a sense, who they are making payment to if they're sued? I'm picking up the sort of assignment-assignee question. Do you get a good discharge? Who pursues you, and where does the money go? at what stage does the defendant have the right to say anything to the court? You'd say it's not entitled to have a say on which or either of the two foreign insolvency proceedings are recognised. You say they can't have a say on that,
I do.
but you'd say it would be when the court came to decide what assistance to give. But the question of which of the two foreign insolvencies you recognise could have a material effect on who is said to own the movables, say. Because as we understand it, the general position is that if there's a foreign bankruptcy which is recognised and it transmits, the movables vest in a foreign trustee, then they have the title to pursue the movables. I think that's broadly what Fletcher and Ferreira says.
That is the general rule, but again,
and so wouldn't the person who's the defendant, or because they would owe the money or they'd have possession of the movables, wouldn't they have a legitimate interest in that sort of scenario of actually saying which of the two foreign insolvencies ought to be recognised in priority to the other?
emphatically not in our submission. Not at all.
So how does that question get resolved? It gets resolved
The court.
in isolate without reference to them, but then what, they come back in at the stage when they're actually being pursued, and,
Yes.
and they can at that stage say what? You shouldn't have recognised because you're not the main insolvency, or
The court could listen to the applications for recognition. If satisfied, it could recognise both. The real question is the next question. That all they're doing is recognising status at that stage.
but if status carries with it under the foreign law the transfer of assets, title to assets, to movables, that's what we recognise. I mean that is a consequence of recognition which flows from recognition. It's not a separate thing. It's my lady's point about how much you can divorce recognition from assistance.
Yes, in this case, there's no question of automatic vesting. It doesn't arise at all. And that's why the judge hasn't addressed it. My only friends don't address it in their skeleton argument.
So, there's no question of these are movables.
Which are, my lord?
Oh, sorry, because you're not making a claim to the English shares.
No, these are the Queeld shares. That they are not.
You are claiming these share certificates.
We don't claim them as automatic vesting. It's not something that's been.
Yes. But in any event, this court's got to consider the
In the slightly more normal
analysis.
situation of where where the reason, I mean, this is undoubtedly on the facts an unusual case where you're not claiming title to movables located in this jurisdiction. You're one step removed from that. But assume the more normal case. I'm just trying to put the argument, and I think my lady was sort of putting to you as well, that in the normal case, there'll be a squabble over movables in
Yes.
this jurisdiction, as opposed to immovables, which we know have different rules attached to them.
Yes.
So if there's a squabble over movables, I understood, and you'll correct me if I'm wrong, but I thought the general understanding was that if, under Russian law, movables vest in a trustee in bankruptcy, the English law would a consequence of recognition of the trustee would be that English law would recognise that was the automatic consequence.
The answer, I think, is that is pure common law, and so the way around that problem would be that in each case, assuming otherwise it was the proper thing to do, both could be recognised in terms of status and authority, but that could be subject to deciding after that the automatic vesting point, because it is ultimately only common law. It's just the judges. It's private international law principles, and so you can carve out that issue for a subsequent hearing. You can decide who the parties are, but it doesn't affect just what I would call the simple question of recognition.
Yes, because I think what might be put against you, I think is in a sense being put against you, is this isn't a bright line question of standing. All of this is a question of, in effect, what the court decides is the most convenient way of organising a dispute. In the sense that, like under the CPIR, the court could, if it wished, hear from the target at the initial recognition application stage if it thought it was more convenient to do so.
We would,
And so, you know, what might be said is, look, the common law is not quite as rigid as you put it. The court has to sort out what to do by way of recognition and what to do by way of assistance, and it can decide when it hears from people who have something relevant to say to the question.
I'm happy to respond to that in this way, that Queeld and Meister have nothing relevant to say about the validity of the bankruptcy order in Russia or my appointment. They have a lot that might be relevant in relation to any involvement I might have in the future in the proceedings. And that's a simple answer to that. I say there is a bright line between the two. One is simply looking at the bankruptcy order in Russia.
But to answer my lady's question, which unless I misunderstood your answer, you're saying that what they can't do is raise the public policy, the judgment should never have been obtained in Russia, or they can?
No, they can't.
So at no stage are they able to come and say, actually the judgment on which the bankruptcy order in Russia was founded is contrary to English public policy.
Any more than the defendant could in this country in relation to a bankruptcy order. And that's to bring it full circle, it's the same point. And we say that that's on conventional, recognised and very sensible principles. And we do say there is a bright line between the two, and we say it's easily drawn. And we say that Mr. Sheldon in particular was well aware of that when he said what he said about the marked distinction between the two stages. May I move on very quickly to the respondent's notice?
Yeah.
You will have seen in our main skeleton, and this is core bundle, at page 365, paragraphs 6 and 7, we say that what the judge...
365?
365, I think, of the core bundle.
That's your skeleton,
Yes.
paragraph 6?
Yes.
Right.
As you know, we say that the judge, if there was any standing in Queeld and Meister, the judge had ample reasons for dismissing their challenge because they came nowhere near close enough to establish what's required to even get a seriously arguable case based on public policy off the ground. And
so the reference to the judge here
is Judge Briggs.
Judge Briggs, and these are those in the judgment, the references, or are they in the transcript? I mean, I recognise those from what was said to Mr. Morgan on the 7th of November, but
Yes, I mean, we think we've summarised this accurately. An unnamed person or persons made a telephone call from the Kremlin to an unnamed judge or judges in respect of an unidentified hearing or hearings. The judges were directed to enter a money judgment against Mr. Ananiev in a run-of-the-mill enforcement proceedings brought against him by a Russian liquidator of a Russian creditor company, and that the judge is duly obliged without a legal basis for doing so.
Well, do we have a reference in the bundle to that where you've taken that from?
I can give you the references after this hearing, but I don't think any of that is controversial. It's also in their pleadings, in their reply in the court below. And what we say about that is that, first of all, neither Mr. Ananiev or any of the creditors support those claims of political interference or challenge recognition more generally. They don't dispute the jurisdiction of the bankruptcy court to make the bankruptcy order. They accept that he submitted to the jurisdiction, was legally represented throughout, and participated fully in the bankruptcy proceedings against him. They do not allege any wrongdoing or knowledge against the petitioning creditor. That's the Russian liquidator of the Russian creditor company. We don't make any allegation of wrongdoing or knowledge against the trustee, because of course he wasn't around at the time. Neither are they nor their representatives assert that they witnessed any of the hearings or have any primary evidence at all that is relevant to their allegations. They say they want to call expert evidence. And they were not in the court below able to identify which of the 4 potentially relevant hearings, 2 of which were decided in favour of Mr. Ananiev, that was subject to political interference.
Who is said to have provided this information to Q&M?
It's based on the judgment.
You'll remember, for example, in Careva, you make a point in the footnote. I mean, there were, I think if my memory serves me correctly, there was actual evidence in Careva from a certain person who said that she had a meeting in a coffee shop with a judge in the local court, and he'd told her.
No evidence whatsoever in this case, nothing.
Right, but that was what happened. That was the evidence in Careva. There was some attempt to identify a person who had a conversation with a judge who had said X, Y, and Z from memory.
Not in Bezhimov, but in Bezhimov, what was said was that the guarantee was forged.
I do remember the guarantee forged. I think both of us remember that.
Yes, and
we agreed in the end result on that, but
the
maybe I'm remembering a different Russian case.
So everybody just got the joke. I was slow. A different case, I think. But of course, the fundamental difference is that in Bezhimov, it was it was the bankrupt who was making all these allegations. He himself was.
I remember the allegations about the guarantee.
So he was giving personal evidence to the effect that it wasn't his signature and all of that stuff.
This one was something else as well, but anyway, but it may be a different case.
Yeah. But there's not a shred of primary evidence in this case. I mean, absolutely nothing.
So who is said to have supplied the information to whoever either made, when you say the case was advanced orally, presumably either on instructions or on the basis of something in the evidence? No,
it's on the basis that Mr. Ananiev is said to be convinced that he's on the receiving end of persecution as a result of his conduct in the bank, which he said was without blemish, and that he was wrongly blamed, and that the Russian state has been after him ever since.
Has Mr. Ananiev
No.
Has put evidence in?
None at all.
And has somebody put evidence in recounting that this is what Mr. Ananiev has said?
Well, not really. I've gone through this with Mr. Ananiev, and he tells me as follows now. We have Mr. Ananiev, I showed you earlier the passage from Mr. Leach's witness statement, which is, it is Mr. Ananiev's case that there's been political interference. But it doesn't have any bearing on court hearings. It doesn't have any bearing on anything that matters. He doesn't attack in any way the petitioning creditor's debt, save to suggest that it was limitation barred. A point that was taken and succeeded at first instance in Russia was then overturned on appeal. He gives no evidence about that at all now. No one does. There is simply no direct evidence whatsoever. There is simply an expert's report compiled, I think, last year, saying that certain things happen in Russia, and there's a reliance on the Zephyrus case, the judgment of Mr. Justice Leach, which we refer to in paragraph 10 of our skeleton argument, in support of the recognition, the respondent's notice on page 15 of the respondent's notice bundle. And as we, I think, with respect to us, rightly point out that anything said, paragraph 11 of that statement by Mr. Justice, I think it's Leach, Henshaw, in Zephyrus, is not admissible. It's got nothing to do with this case, and it relates to a post-Ukrainian war point that related to the Ukrainian war. Our case is plain and vanilla as you can get. A Russian liquidator on behalf of a Russian creditor getting judgment against the debtor, Mr. Ananiev. He appealed against that. The liquidator was refused at first instance, appealed, was successful, and there is not any evidence anywhere about that process other than what we have garnered from the public documents and from the judgments, which are very full and are in the bundles. That's it. There's nothing there.
So the appeal was unsuccessful.
The appeal was successful in that in the Court of Appeal, the Russian liquidator succeeded in establishing that the debt was not statute barred, very much along the lines of
Sorry, I see what you mean.
Yes.
Sorry.
Hill and Spread Trustee. The time started to run again when the liquidator was appointed, which is similar to our jurisdiction. There's not even. It is suggested that that decision, I think, is the product of a telephone call from the Kremlin in the abstract, with no evidence at all of anyone who was there, let alone witnessed anything untoward or wrong. And even in the case that they rely upon, the Severus decision, Mr. Justice Henshaw found that in most what he called run-of-the-mill cases, Russian judges act independently and impartially. That's the high point of Queeld and Maisper's case, their reliance on the judgment of Mr. Justice Henshaw. And we say you can't get much more run-of-the-mill than the application against Mr. Ananiev by the liquidator of the creditor company. And all of this was set out in the second half of the judge's judgment, where he went through the judges, the Russian rulings, and we'd see in his judgment at the very end, having gone through all of them, it matters. He concluded that there was no evidence at all of any public policy grounds and as a bar to recognition, and he was absolutely right with respect to him to make that conclusion. Now, I'm painfully aware of the time. Our case on that is set out in our respondent's skeleton argument, which is at page 11 of the respondent's bundle.
Don't despair, Mr. Davis. You've got 10 minutes. So I've got a timetable here that says 3:45.
That's music to my ears. Thank you. I got that wrong.
I'm simply going on the timetable I got on Friday.
May I remind you that Judge Briggs on the 15th of November ordered the respondents to file any evidence that they wanted to file in response to the recognition application, and they did not do so.
Yes, but that order was set aside, wasn't it?
It was, but they applied after the time had expired to set it aside. But yes,
The time expired on the 6th, and you say they applied on the 9th.
You said
Those the dates?
no, there was an earlier issue and
it was issued on the 26th, I think.
yes.
But when was the time for the
Was it
filing?
issued before the expiry?
So, my lady, I think you're absolutely correct. I think it was that it was issued on the.
But it is important that that order was, or potentially important, that
Yes.
that order was set aside. Yes, they were required to file evidence, but the order under which they were required to file it was set aside.
But may I remind you of this, that the first time that recognition was raised by Queeld and Maisper was prior to the trial in November 2023. They raised it again in March 24. They raised it in October 24 and in November 24. And as we are today, we have still not seen any evidence at all of the alleged political interference. All they do is rely on the judgment of Mr. Justice Henshaw in Zephyrus and an expert report that says that the limitation point is, I can't remember the adjective, something like troubling or highly unusual. That's it. There isn't anything else. And
I suppose what concerns me, in the light of the that order having been set aside and the hearing repurposed to hear those 4 applications, the parties didn't come to court before the ICC Judge Briggs to hear effectively a summary judgment application, which is really what you're seeking via the respondent's notice. And normally on a summary judgment application, there will at least be the opportunity to file evidence on
Yes,
this.
but my lady, the point I am making is that in the snowstorm of paper that we've got in court and the very many witness statements, there is no primary evidence at all, not even an indication of what it is. There's nothing.
So you'd say even though they hadn't got to the point of actually filing evidence, there should be something in all that snowstorm.
There must be something. And may I remind you that they have pleaded their case out in the Eurasia proceedings. They got their reply now, where they have a duty to, and we were very keen to get that. And you can look through that reply and you will not find any material facts which are primary facts.
And just on the order being set aside or otherwise, the application was issued prior to the date for service of the evidence. I think, is this right? Your skeleton says that the application to set aside was not served until after the time it expired.
That's right.
Is that right?
That's right.
So although the application was issued earlier, it wasn't served until after. Anyway,
Yeah,
when you say putting the technicalities aside, you'd expect if they really had something, they would have been shouting about it at some point in the last couple of years.
If there were relevant primary facts of the nature that we've just sort of outlined, there are none. And I mean there is nothing. It is that, oh, things happen in Russia. Look at Mr. Justice Henshaw. There's a judgment about the Ukraine war. And I've got an expert that says the limitation point is a bit dodgy. That's it. It's in circumstances where the bankrupt was fully represented, was acting on appeal, tried to appeal again, did not appeal on the limitation point as far as we're aware, and has ever since then has been fully represented and taken every point he can, and he has never raised this limitation point. First person to raise them is the expert in that report. And all she says is no more than it's highly unusual. And as the judge said in his judgment, she gives no reasoning at all. She certainly doesn't suggest anything which would result in this court identifying a seriously arguable case that the Russian judgments, or any of them, were, quote, manifestly offensive to some basic fundamental principle of morality or justice, because that's the test. It's a very high bar. Everybody has agreed that. And we don't even get out of the blocks on this case. And for the reasons set out by Judge Briggs in his judgment, in the second part of his judgment, he had every reason to say we need to move on from this. You cannot suggest that you have standing to have a five-day trial with expert evidence and so forth in circumstances where there's no case articulated.
You took us to your skeleton in the respondent's notice bundle, which behind tab 2, which we've read. Is there any particular passage in that you want to refer to, or were you just doing that to remind us that that's where your case is?
There are three more points I'll briefly make by reference to that skeleton, and then I'll sit down. The first is that, just picking up the very last point I made, could I invite you to go to paragraph 19 on page 18 of the bundle? That's 19 of that same skeleton argument.
Mm-hmm.
And that is a decision of Sir Julian Flo, who, in that case, which is an interlocutory application, found that allegations which were far more detailed in that case of corruption of the Turkish court, quote, with nothing remotely like the extreme and egregious cases where the exception to recognition would apply. And that's recognition to ordinary judgments. We say that in this case, in the absence of any primary facts which would permit even a possible inference of judicial interference, the similar description could be applied to Queeld and Maisper's case. And then the two other points of these, could I just invite you to by reference to paragraphs 21 to 26 of this skeleton on pages 18 and 19 and 20, just to mark the point that so far as the so-called jurisdiction challenge is concerned, our case has always been that it is not a jurisdiction challenge. It was a challenge under CPR Part 11 to the effect that permission should not have been given to serve out in respect of paragraph 2A.
Remind me where paragraph 2A is, I've lost it.
That's the,
I know what it is, so just remind me where it is.
it's in the skeleton, my lord. It's same skeleton, paragraph 22, 2A, bottom of page 18.
Okay, well, all right, well, let's get it there then. Sorry, it's 25.324. Okay. The shares in the respondents are located in BVI and Cyprus.
Yes, we take a different point, if you don't mind me saying so. The point we take is that this isn't on authority, this isn't a CPR Part 11 point at all. On authority, and that's the authority referred to at paragraph 26B of our skeleton on page 20, as recited in the White Book, as shown there. This is not a correct means of challenging 2A. The correct means of challenging 2A would be to apply to either strike out or to apply for reverse summary judgment.
Except you were given permission to serve that application,
Yes.
including paragraph 2A, out of
Yeah.
the jurisdiction. You asked for it and you got it.
Yeah.
And it said you shouldn't have got it.
And
Why can't they apply to say you shouldn't have got you serve out in relation to that paragraph?
because CPR Part 11 can't be spliced up, claim spliced up with relief. That's the gist of what Lady Moon holds. In other words, you look at causes of action, that doesn't work at all well in terms of recognition and assistance. And if you think that the court has not got the power to grant assistance under 2A, then you apply to strike it out. What you're not doing is attacking a gateway point.
Is that just are you just saying that's a process point?
Well, it's
What's the substantive answer?
The substantive answer is
Does this court have jurisdiction to grant assistance in relation to shares of companies incorporated in Cyprus and the shares of companies incorporated in Cyprus and BVI?
it has jurisdiction to give assistance in this jurisdiction to the trustee, and that could include, as an example, allowing him to enforce the October 2023 ruling, because that's a ruling that's been made against Queeld within the bankruptcy.
Sorry, how enforce it? The 2023 ruling says that the shares of Queeld are owned
Yes.
by the bankrupt and therefore by the trustee. What more should this court be doing about that?
Well, he would be seeking assistance. Queeld and MySpare are in this jurisdiction, and he would be seeking assistance against them in respect of.
Sorry, what?
They're not.
No, I'm so sorry. I mean, they're in the jurisdiction of this court because they are before this court.
Yes, but the order of the court in the bankruptcy in Russia says that the shares in Queeld
Yes.
held, which are registered in the name of Mrs. Anayev,
Yes.
form part of the bankruptcy estate of Mr.
Yes.
Anayev. I mean,
Yes.
that's not an order against Queeld in any way, shape or form.
Well, Queeld participated in those proceedings. Queeld defended those proceedings in Russia, and we would say there's an issue of estoppel. They were the acting defendants. I mean, we've got the judgments they're there taking all the points, and we would say that they are that's a regular judgment, and they.
So the order of the Russian court was Mrs. Anayev has to give notices, I think, or procure the change in the register of Queeld in Cyprus,
And obey the directions of, and Queeld must obey the directions of the trustee.
Was that? Or Queeld, there was an order against Queeld.
I think so. If we saw the order yesterday, it's at the back of the respondent's notice bundle, I think. Tab 28 in the supplemental bundle, is that right? Yes, it is. It's the
We looked at page 380, which is the order against Mrs.
Yes, this order is, it's our case, this order is binding on Queeld. Queeld participated in these proceedings and can be enforced against Queeld.
There's no order against Queeld.
Not in terms, but it is in respect of the entirety of Queeld's share capital.
If you'd have told me that there is an order against Queeld here, my questions as to why on earth you haven't gone to Cyprus are ones that I would ask again.
Yes.
I mean, if you're saying you've got what's tantamount to an order against Queeld from the Russian court, why on earth have you not gone to Cyprus to enforce it?
Because Queeld is questioning, challenging the jurisdiction of the Russian court and has always done so, and doesn't accept that it's bound by this. Queeld's case is it's not bound by this.
Right, but I mean, at the moment, I don't see where there's an order against Queeld anyway. I mean, it's the obligation is placed upon Mrs. Anaeva to take actions to make changes to the composition of the shareholders of Queeld in the Trade Register of Cyprus. So it's an order against her, not against Queeld.
And we would use that as a reason for applying, if it was otherwise appropriate, under 2A for an injunction by way of assistance to preserve those shares in aid of that order.
On what basis?
On the basis that this court would be assisting the trustee to, in effect, indirectly to get the share certificates which are in this jurisdiction, the Eurasia certificates. That's the way in. That's one way into that. By controlling Queeld.
Why does getting share certificates of Eurasia, an asset of Queeld, assist in any way, shape or form in bringing about a change of the share register of Queeld?
Because we can then control Queeld.
Sorry?
Well, the idea is...
Sorry,
this,
I'm sorry. Have I just stepped into a parallel universe, or am I just being incredibly stupid at 10 to 4? Who owns the share in... The shares in Eurasia that everybody's talking about,
yes,
in whose name are they registered?
Queeld, I think, in my side.
How does getting hold of the shares in Eurasia give you control of Queeld?
Oh, I'm sorry, I got it the wrong way around. I'm sorry, I didn't hear the question that way at all. It doesn't. Not that way around.
No, it doesn't, does it?
No.
I mean, so...
I understand now.
Right, so you understand why I'm baffled?
Yes, no,
Okay, sorry, it's been a long day, I was just... But,
I must sit down as well, I'm sorry.
okay, but I am really struggling with what jurisdiction what is the basis for the order in 2A?
The Russian court has given a judgment in respect of the shares in Queeld. Queeld owns assets in this jurisdiction. We would ask this court for assistance to get hold of the assets in this jurisdiction via the court ruling. That's what we would do. I mean, that's the purpose. The purpose of the assistance in this jurisdiction is because ultimately Queeld's only asset that's known about is in this jurisdiction. So that is why we would ask for assistance here.
That's 2B.
It's 2A as well. Protection and/or preservation. So that could be interim orders. And the simple point taken on the jurisdiction challenge is this isn't a jurisdiction challenge. This is saying the court, there's no arguable case for court granting that relief. And granting relief is not a CPR 11 point, that's our Lady Moon and White Book point. It's just an ordinary strikeout or reverse summary judgment point. But I also commend to you the other grounds that we set out there, C, D and E. And finally, I respectfully ask you to find that there was no procedural unfairness so far as the standing issue was concerned in its resolution before the judge, because actually my learned friends had ample time to put any authorities they wanted to before the judge, especially having regard to the fact that they had overnight from the end of day 1 to day 2, and they'd known about our standing point for some time. I've gone over my time, I'm afraid.
Yeah, only 5 minutes or so. That's fine. Thank you very much, Mr. Davis.
My Lords, I'm dealing with the respondent's notice point. If I can begin just by pointing out what we were in fact dealing with overnight before coming back before the judge on day 2 was the proposal we made to resolve the injunction application, which had been worked up at some length overnight and was then explained first thing in the morning. And we'd certainly not come armed to deal with the standing point. We simply didn't understand that to be on the cards. We were just about to fight what we thought was going to be a heavy and hard-fought application for an interlocutory injunction. Now, what's sought on the respondent's notice is to uphold 2 decisions on the recognition question, effectively by saying this court should grant summary judgment in circumstances when we had no opportunity to deploy our case evidentially below and no opportunity to deploy our case in argument below, when we were served with the respondent's notice a week ago and have had no chance to put a skeleton or evidence in responding to it. On the CPR 11 application, it's based on an erroneous contention as to the way the jurisdiction rules work. Now, just beginning with recognition, very briefly, I'm sure my lords, my lady have the chronology in mind, but the core point is that the expedition order, which provided for both an expedited timetable with evidence to be filed by the 6th of December, leading to a final hearing on the recognition application with a 2-day estimate in the middle of January, was obtained ex parte, objected to on the basis it was unfair and unachievable, then set aside by Mr. Justice Mead, whose order set aside the directions for expedition. It set aside the direction for us to file any evidence at all, and it vacated the final hearing of the recognition application, repurposing those 2 days to deal with the 4 matters enumerated in Mr. Justice Mead's order. That was the middle of December. We had slightly less than a month over
Were
Christmas.
you seeking the repurposing?
We said that all those things should be set aside.
All those things to be dealt with? Should be dealt with first?
One of the things the trustee was saying was he wanted or might want to apply for an injunction. If the undertaking was the reason the trustee said he wanted that hearing then was that was before the undertaking was released on the 24th of January. Mr. Justice Mead said, in substance, you ought to have a chance to apply for an injunction before the 24th of January. And you, Q&M, should not be entitled on the injunction application to say you, trustee, have no standing. And therefore, Mr. Justice Mead extracted from Mr. Hankey the confirmation that's set out in the recital to the order, so that essentially what was going to be in play on the application for an injunction would be whether the trustee was prepared to put up a cross-undertaking in damages with appropriate fortification. So that was what was intended to be dealt with. If the trustee would, if he was prepared to put up a fortified cross-undertaking, get an injunction, we'd have an argument about whether we should have security, and the application substantially would proceed on a defended basis. And we'd understood that all the questions raised would be adjudicated upon in the context of that recognition application. That's where we stood. That's the reason we filed no evidence on this. Now, it said against me, well, you couldn't sure have filed evidence ages ago, but at no point prior to the 5th of November 2024 did the Russian trustee bring forward a case anywhere that he was entitled to recognition. He didn't apply in Cyprus, he didn't apply in the BVI, he didn't apply here. and that's notwithstanding that the Russian order was made as long ago as February 2021. In all of that time, there's been no application anywhere. We could not have been expected to go on the offensive and apply for a negative declaration, nor could we be expected to pull together all the evidence we might deploy if and when the application for recognition came to be made, wherever it came to be made, and on whatever basis it came to be made. Now, what's made against us in paragraph 26 of the RN skeleton are a series of points, all designed to show we don't have a case. So that only makes sense if QNM ought to have brought forward a positive case at any of these junctures. Now, it's also said against me, well, the reply doesn't plead the evidence, it doesn't plead primary facts. What we do plead is what we suggest is a properly triable case, that the Russian bankruptcy order was procured by political interference. We are not obliged to plead evidence, and fairly unsurprisingly, where the contention of that sort is made, it is vanishingly unlikely anybody is going to be able to procure evidence that the judge's clerk was conveyed a message or something of that sort. That evidence is simply not of a kind likely to be available.
Sorry, you've got to plead the facts upon which you, the primary facts upon which you rely. I agree you don't plead evidence as such, but you've got to at least plead primary facts from which the inference that you seek to draw.
And we say we do that.
So
We say we do that. And in terms of the evidence we're going to be able to apply to deploy in due course to support that, I'll be coming in a moment to Zephyrus, because I rely on that to show the kind of evidence that is available, the kind of really credible expert evidence that is available about the Russian legal system. Mr. Justice Henshaw had before him a very large volume of evidence, and there is a very detailed analysis and discussion of that presents what I can only describe as a disquieting picture about the state of play.
Which paragraphs of the pleading are you saying that contain the primary facts upon which you say you can infer that the claim that led to the bankruptcy was...
Well, I'm not going to, in the time available...
Just give me the reference.
It's, forgive me, my lord, the critical bits in our reply are... Perhaps I can give my lord the reference to those at the end.
Okay.
The points, though, are said to be, we ignored correspondence from the trustee, well, so what? We were under no obligation to respond. It's then said in the context of the Eurasia opening, we didn't say much more than that the trustee hadn't applied for recognition. But in that context, we didn't need to say more than that. All we needed to say was, well, the trustee's had years and years and hasn't come to England. We didn't need to go further and say, if he were now to change tack and come to England, we'd have a whole series of other points as well. It's also said that we didn't object to the trustee's joinder to the Eurasia action. That is not correct, because the order that effected joinder, that's Mr. Justice Adam Johnson's order, as my friend was at pains to point out yesterday, was without prejudice to QNM's entitlement to challenge standing. That's set out in the recital. The joinder was expressly on terms that we were leaving open our right to challenge standing. Then it said we breached Griggs' order, if I can call it that. That's wrong, because that order was set aside by Mr. Justice Mead. Then it said we don't identify relevant evidence. In that context, that's because we haven't had any chance to put it forwards. We spent a month running around dealing with an injunction application, dealing with security for costs, getting ready for a very heavy 2-day hearing, at which recognition was not to be addressed. We cannot be criticised in those circumstances for not putting together our evidence. But I do rely on Zephyrus to show the kind of material that is out there and the kind of picture that expert evidence will paint. And if I can just invite attention very briefly to that, it's on Authorities 3, tab 47. This is a judgment in the very complicated Russian aircraft litigation, where Mr. Justice Henshaw, amongst a vast number of points, had to decide whether justice could be obtained in Russia. And he had before him a great deal of evidence about this. And if I can pick it up in paragraph 204, that's page 1268 at the bottom, and just summarising some of this evidence, it was common ground between the experts in cases which are of sufficient interest to it, the Russian state is both willing and able to interfere. Then at 209 to 212, as Dr. Gould Davis's evidence set out, the Russian state views the judiciary as a means of achieving state objectives. Then in 210, Dr. Gould Davis states it's widely accepted there's no strong tradition of the rule of law. A bit further down, the judiciary lacks independence from the executive branch, and judges' career advancement is effectively tied to compliance with Kremlin preferences. Same kind of points in 211 and 212. In 215, he talks about telephone law. In 216, he talks about the wide gulf between appearances and the reality. At 218, there is further evidence. The road of the legal system is today more clearly than ever to serve as an instrument of state power. Then turning forwards a little to 242 and to 243. I do invite attention to all the sidelined passages. Then a reference to the increasing authoritarian nature of the state. And then at 258 to 263, there are the conclusions that Justice Henshaw drew. And it's in this context that my friend points out 263, but the critical bits in 259, common ground, at least between Personek, Dr. Gould Davis and Professor Antonov, that in cases which are of sufficient interest to the Russian state, it is capable of affecting the outcome. Then at 276, it said on the totality of the evidence, consider it likely a Russian court would be directed, explicitly or implicitly, not to make a decision adverse to our NRC in any of these cases. That's because of the interest in that state. Now here, the position is that Mr. Ananyaev was one of the founders of PSB. We say, and this has never been controverted, that PSB was expropriated by the Russian state. That's never been controverted, never taken issue with. Nor has it been controverted that Interpol was correct to conclude that the prosecution of Mr. Ananyaev was politically motivated. And we say that these insolvency proceedings are all of a piece with that, designed further to cement control of PSB or attack Mr. Ananyaev, or both. And these are not fantastical allegations, they are allegations that are entirely consistent with the basic facts in relation to PSB, consistent with the views of Interpol, and consistent with the very extensive expert evidence that is obtainable and is summarised in Zephyrus. I accept, of course, a Hollington and Hewthorpe point could be taken against that. I can't rely on it as evidence, but I can point to it as showing the kind of evidence we would be able to obtain if given an opportunity. Now, what all this comes to is that we've had no opportunity to set out our stall on any of this. And in those circumstances, it would be entirely wrong for this court, in a 20-minute odd hearing, to decide there is no triable issue. If my friend wants to try and strike me out, well, he can go to the judge in the Chancery Division and make that application. Now that brings me to the CPR 11 aspect of the RM.
Just before you get to the CPR 11, I mean, other paragraphs that are at the core of your case, is it paragraph 28 at page 140 of the respondents bundle?
It's a little more than that, my lord. So there's some background.
I appreciate some background pleading of the Russian bankruptcy in paragraphs at page 138.
It's 19 through to...
Yeah, it starts 138,
yes, that section.
Sorry, I'm not with
Respondents bundle, tab 3, page 138, my lady. This is the reply pleaded in the erasure action, setting out our case on the Russian bankruptcy. Now, if I can move on to the CPR 11 aspect, try and deal with that crisply.
I mean, would you accept that there are the core criticism you make, is this right, of the making of the bankruptcy order is of the 9th Commercial Appellate Court?
Yes.
And the only place you deal with that is at paragraph 28, 3 and 5.
Well, we say it was wrong. It's 28.3.
Yeah.
we say it's wrong as a matter of Russian law. It's inconsistent with a decision which was binding on that court, and that the explanation for that is that this is superficial appearance of justice, but in fact nothing of the kind.
Did you appeal? Sorry, did Mr. Aniyev?
I'd need to take instructions on that point. But again, these are the kind of detailed points that it might be relevant to investigate.
The fact that a Russian court might have got a decision wrong in the sense of being contrary to binding authority doesn't indicate that there's anything wrong as a matter of public policy.
No, it does, certainly not.
With the process, because I mean, goodness me, we'd all be in trouble.
But I mean, as a matter of private international law, it's no answer to say that a foreign judge got it wrong as a matter of law or fact. That's well established.
Yeah.
But we say that it's so wrong that when taken in its proper context, it is enough to raise a triable issue. And I don't need for present purposes to go further than that. And the political context surrounding PSB is what matters here. That political backdrop cannot be understated. PSB was expropriated. It was turned into the Russian military bank and is now being used to fund the Russian military defence, the Russian defence sector.
Okay, well, I mean, that's as maybe, but why would that?
That founds an additional public policy point.
What, that we shouldn't grant recognition to a trustee of somebody who was made bankrupt on the behest of a Russian bank that happens to now be funding the war in Ukraine?
It wasn't, in fact, on.
That's quite
It
wide
wasn't.
public
It
policy
wasn't on its petitioning. The petitioner was the grain company.
Okay.
PSB is the largest creditor. It's
Very
the
fairly making
it's the 99.5%.
Okay,
credit.
so, all right, I could raise, that's one step further removed, but, I mean, that's a long way from public policy, isn't it?
No, it's not.
Well, the public, as I would understand it, the concerns that UK court would normally have in recognising a foreign judgment as a matter of public policy is not because of the person who obtained it, because they're bad people,
Quite.
but it's because of the process by which that judgment
That
was obtained.
is. I entirely accept that. That is normally.
So whatever the bank is doing, how does that can't be relevant to the question of public policy?
It
So,
might.
I mean-
It might be that if the monies that would flow into the estate would flow out as to 99.5% of PSB, which bank is engaged in prosecuting or aiding the prosecution of an illegal war of aggression, and I do put it that high, that round raises a point of wider public policy, not in fact addressed in any authority thus far. But what is going on here is that the PSB is the Russian Defence Bank. It is not some kind of conventional commercial bank. That it will use monies it receives to prosecute the war in the Ukraine indirectly. And we do say that there is a genuine public policy point in there. Now that's not the main point. It's a very much a subsidiary point, but it is a point we rely on. Again, these are all points that have not been ventilated or argued about below. If my friend wants to say that our pleading is liable to be struck out and wants to have an argument on an interlocutory basis about quite how wide rules of English public policy go in the public international law context.
In my view, there's been far too many interlocutory hearings and not a substantive hearing.
My lord, yes.
And from those of us who are not used to the Chancery Division, I feel very sorry for the Chancery Division judges because they spend all their time dealing with a load of shadow boxing and not actually dealing with the real thing. But I say that as somebody who obviously didn't sit there.
Well, as an habitué of the commercial court, I can sympathise with that view.
Anyway, okay, we've
It's
got that.
only purity of the TCC which saves the English legal system.
Thank you very much, my lord.
If I can move on to the CPR 11 aspect,
Yeah.
there are four basic principles which we suggest dictate the outcome of this. First of all, as we all know, a shareholding is an incorporeal, movable, situated in the law of the place of incorporation, or possibly where the register is maintained. If authority is needed, it's Althani and Althani. Second, to bring proceedings with Q&M as
So
part.
you're going to have to keep your voice up. I'm sure the transcribers will
Forgive
not
me.
have picked up that, and you might want to point a microphone towards yourself.
Oh, forgive me, my
But
lord.
but can you give us that authority again for the transcript?
Yes, it's Al-Thani, that's Authorities 3, tab 48. That's authority for the proposition that the shareholding is an incorporeal movable, cited in the place of incorporation or possibly the place where the register is maintained. See Al-Thani, paragraphs 37 and 39. Second proposition, to bring proceedings with Q&M as parties, it was necessary to serve them out because they are not within the jurisdiction of the court and have not submitted by contract. That was the basis on which the trustee approached matters in his skeleton for the ex parte hearing, see paragraph 24. Thirdly, obviously, to get permission to serve out, each claim advanced must pass through a practice direction 6B gateway. And the authority for that is Transworld, that's supplementary authorities, tab 3, page, paragraph 59. And I stress each claim, and each claim in the sense I'm going to come on to in a moment. Now, thirdly, Gateway 11 applies where the whole subject matter of the claim relates wholly or principally to property within the jurisdiction, provided that nothing in this paragraph shall render justiciable title to or the right to possession of immovable property outside England and Wales. Now, what that means was considered in Vestel. If I can just invite attention very quickly to Vestel, this is Authorities 2, tab 36. This is a rather complicated IP case, but the critical bit is at paragraph 61 and paragraph 70. So,
Wait.
Dear Lord. Authority 2, tab 36. So
61 sets out
61
gateway.
sets out the.
Yeah.
Then over the page at 70, the test is set out. I would interpret the reference to a claim in Gateway 11 as a reference to a legal claim. In other words, it refers to a claim concerning a legal right of some kind and in some way, etc. There must be a legal claim of some kind about the property in England. So without a claim, in that sense, in relation to property in England, Gateway 11 is not open. Now, we looked earlier at the recognition application. I'm not going to get back to it. It sought recognition at common law. Now, that alone of itself cannot pass through a CPR 6B Gateway 11. Cannot pass through Gateway 11 because it's not a claim in relation to property within the jurisdiction as explained in Vestel. So if the trustee had issued that claim on its own, he could not have got leave to serve out on my client, or indeed anyone else, because it would not be a claim in relation to property within the jurisdiction. So what he had to do was to go on and assert the things we saw in A and B. Those are claims in relation to particular pieces of property. And the question then is, where are those pieces of property cited? 2B is about the Eurasia share certificates and the Eurasia shares. There's no dispute that those are in England. On 2A, as my Lord Justice Snowden pointed out, those are shares in Q&M cited in the Cyprus and the BVI. Those are not pieces of property in England. The claim of the kind identified in Vestel about them is necessarily not a claim in relation to property in England. It's a claim in relation to property situated outside the jurisdiction. And so we say this is quite simple. For the purpose of service out, there are two claims being identified, one in relation to property within the jurisdiction, one in relation to foreign property. The claim in relation to foreign property is not one over the court has jurisdiction. CPR 11 requires a jurisdiction challenge properly so called to be made and determined at the outset, because if I don't make it and I participate, I submit, and I lose my right to make my jurisdiction challenge. What I am advancing is not a discretionary question about relief or whether particular relief should be granted. It is about jurisdiction in the true sense, about a particular claim understood in the Vestel sense. And in that sense, as I say, the claim to recognition is not the claim on which jurisdiction rests. The hook to get jurisdiction is a claim in relation to property in England. Now, I hope I don't need to go through my friend's points about this and deal with them in detail. But I do say that those are right. The court has no jurisdiction because there is no available Gateway 11 opening in respect of the shares in Q and M, and it's as simple as that. As for how my lords deal with that point, well, my lord and my lady might feel able to decide it, otherwise it'll have to be remitted. But I do say it certainly cannot be decided in favour of my friend in the way he says it should be, unless I can assist further on the RN.
Lord, my lady, I was meant to be replying now. I see the time. I don't know whether there is any room for indulgence or not. I'm entirely in your hands.
Well, there's the timetable anticipated, the reply submissions and the submissions on the respondents' notice finishing by 10 past, so about 10 minutes over, and 5 minutes reply on the respondents' notice. So how long are you going to be? If you're going, I'm assuming, I may have to indicate that if you can be about 5 minutes and Mr. Davies can be about 5 minutes in reply on the respondent's notice point, and that'll take us to 5:30. And I think that's fair on the court staff.
I'm extremely grateful to all of you for that. Thank you.
That's right. You've generally done very well sticking to the timetable, but it is important. Okay, so 5 minutes on the reply to the submissions by Mr. Davies on your appeal.
Correct. And starting with 2 points from this morning that were left over, the Mr. Carter point from the Sturgeon case. I went back to read the judgment again. Like my Lord Justice Snowden, I still can't see what interest the judge thought that Mr. Carter had. There's no further guidance in the judgment. The other point left over from this morning was about the evidence in support of the recognition application and whether it dealt with paragraph 1 or paragraph 2. My Lord Justice Snowden addressed the same question to my learned friend, who fairly answered that it deals with the whole of the application, both parts.
Yeah.
In terms, therefore, of true reply points, a point was made by my learned friend that it wasn't until the 9th of December 2024 that it was understood that Q&M would be taking any points on the recognition part of the application. That's simply not right. In the transcript of the hearing before the ICC judge on the 15th of November, Mr. Davies said, it was made absolutely plain, and you will have seen this from the Frank section of our skeleton argument, that they're going to take every point, if I could put it that way, in relation to this application, the recognition application. That is supplementary bundle 2, tab 35, page 468. And the reference to the Frank section of the skeleton argument is the full and Frank section of the skeleton argument, including those numbered points which said Q&M might raise, including the sick fee that I took you to earlier.
But the transcript you just referred to, but wasn't he effectively saying this is what we envisage?
They are going to take every point.
Yeah, we're guessing they're going to take. You couldn't.
But the suggestion that until they were taken by surprise in December because it was only Mr. Ananyov who might be opposing is simply not right. The point goes nowhere, but it's just to correct it. In terms of the busybody point, I mean, I do go back to the Dalnyaya Step case. The Hermitage parties were not considered by the court to be busybodies simply because they weren't creditors or the debtor. They had an interest, the court held, in being able to apply to set aside the recognition order to avoid having to be the subject of the Section 236 application. And eventually, my learned friend, I think, accepted in argument that it wouldn't have been available to the Hermitage parties, just by way of analogy, to have taken the public policy point at the assistance stage, i.e. on the Section 236 application. They couldn't take it at the recognition stage, they couldn't take it at the assistance stage. It's obviously right that a public policy type argument should be taken at the recognition stage because it's the recognition order in relation to which the public policy point is taken. There may be no answer to a Section 236 application if the insolvency office holder is recognised. Section 236, does the office holder have a reasonable requirement for the documents? Would it be disproportionately burdensome on the respondent to provide them? Those are the issues that arise. the public policy question doesn't arise at that stage. It arises at the prior stage of the recognition application. But in any event, my learned friend's case boiled down to it not being open to a stranger to the insolvency to take a public policy point at either stage, and we say that that's fundamentally wrong. In terms of the analogy with a bankruptcy order, we suggest that there is a material difference between a bankruptcy order made by this court and a bankruptcy order made by a foreign court. The question of public policy arises because the bankruptcy order made by a foreign court engages a public policy angle. It doesn't when the bankruptcy order is made by the English court. And therefore, looking at what could happen on a bankruptcy petition and who would be heard in relation to that doesn't assist and rather misses the point. In any event, I do suggest that there may be extreme circumstances where the court may hear from an outsider to a bankruptcy at the petition stage. My lords and my lady may remember that there was a stage pre-Brexit when German dentists and doctors were trying to come to this jurisdiction to bankrupt themselves to take advantage of our shorter period for discharge.
There was a flat in Leeds in which apparently about 40 people were living there.
Right. So, my lord, if, for example, a bankruptcy order were made on a debtor's petition in those sorts of circumstances to open a gateway for a 236 application to be made against someone that he was litigating against, or to make available the preference jurisdiction or the transaction and undervalue jurisdiction, I query whether the person who would be on the wrong end of those applications would have no standing to come before the court at the petition stage and to identify that the debtor in fact has nothing to do with this jurisdiction and the petition is in fact an abuse. Now, I don't need to go that far because the prior point is the important one, that public policy arises in relation to a foreign order, but not the English order. But I suggest that my learned friend goes too far in suggesting that in all circumstances, a stranger to a bankruptcy has no standing to engage with that bankruptcy process at all, other than in his or its capacity as a respondent. The final point I just wanted to make for completeness is this. My Lord Justice Snowden raised the possibility of rival applications for recognition. That is not something which is out of the question. In fact, my Lord may remember the Stanford International Bank case, which went before Mr. Justice Lewison for about a week and then to the Court of Appeal for another week, where there were applications made by the Antiguan liquidators of the bank and also a US receiver who had been appointed on behalf of the SEC in the States. And the issues were principally as to where the bank had its coming to see where the main proceeding was, but also in relation to whether the US receiver had been appointed pursuant to a law relating to insolvency and so on and so forth. So it's perfectly possible that there will be more than one process. And in that context, I'll adopt the point suggested by my lord, that it may be that the person who is going to be on the intended target of whatever assistance is sought next, or for example, the defendant to litigation, may have something to say and may be entitled to be heard on those rival applications. The bottom line is there should be no hard and fast rule that a stranger to the bankruptcy should have no ability to appear on a recognition application. That is far too blunt. The question for the court will be in every case whether it's appropriate to hear from that person. But we do submit that where one has a recognition application such as this, made on the basis this was for the purpose that this recognition application was made, it is simply wrong to suggest that Q&M had no standing, no legitimate interest in being heard on recognition, no ability to make any public policy type at that stage, or indeed at a later stage in relation to an application set aside or on the assistance part of the application. It is a matter for the court when such opposition is heard, but the obvious place for that is in the context of the recognition application. And my Lady Justice Falk mentioned a couple of times to my learned friend the thinking of Mrs. Justice Rose, this is my final sentence in Down the Eye Step, that the time at which the judge might have wanted to hear from the Hermitage parties was on the recognition application. I just remind you in that context that the Chancellor thought the same thing. That's the final sentence of paragraph 87 of his judgment behind tab 2 of the Supplemental Authorities bundle. I've probably exceeded my 5 minutes.
No,
so
that's
unless
fine. Thank you very much.
Very briefly.
Mr. Davis, your 5 minutes starts now.
Thank you very much. I only want to speak briefly to 2 points. The first is the pleading by Queeld and Maisper of the political interference in paragraph 28 of the reply on page 161 of the Respondents' Notice bundle, which we went to briefly, setting out their case there. Could I make 3 points, please? The first is, may I just state what we state in our skeleton argument, that this judgment that is impugned in this pleading is more than 12 months prior to the Ukraine war, the invasion, or anything of that nature. Secondly, could I just remind you, by reference to our skeleton argument, in particular, our Respondents' Notice skeleton argument, paragraph 11, page 15, that there are 4 relevant judgments. The first was the judgment where the liquidator of GCN, the equivalent of the petitioning creditor, had his application for a money judgment dismissed. The second is the one that's referred to in the pleading. That's the judgment of the Court of Appeal on the 19th of December 2018. That was not appealed against. The third was then the judgment dismissing GCN's liquidator's petition for bankruptcy. That's dealt with in paragraph 11D of our skeleton at first instance. And the fourth was the differently constituted Court of Appeal on the 15th of June 2020, that's paragraph 11E of our skeleton, actually in effect making what we would call the bankruptcy order, albeit first phase Russian style. And as I understand it, that the colours have been pinned to the mast in paragraph 28 of this pleading, on grounds that are no more than there's a court, something has happened behind the scenes to mean that the judges have been corrupted. It's the second of those judgments which is impugned, and purely on the basis of an alleged error of law by reference to a limitation period. And the third point I would like to make is that if that is the judgment which is impugned, because that's the operative judgment, I would respectfully ask you to observe that the bankrupt did not appeal against the bankruptcy order on that ground either. That is to say, the second Court of Appeal judgment, differently constituted court. So at no stage did the bankrupt raise the limitation point, which is said to be so manifestly awful that it offends the public policy considerations in this country. And the Ukraine war has absolutely nothing to do with it, because all of this occurred long before the war, the invasion, call it what one will. Secondly and lastly, could I just emphasise the point in response to my own friend's points on CPR 11. We do not accept that he can, that assistance is something which can be analysed for the purpose of CPR 11. It's the question under CPR 11 is whether there was an arguable case for recognition and some form of assistance. What you don't do under CPR 11 is say that permission should not have been granted for one possible head of relief in the future. That is not something that CPR 11 is designed to do, and that's what the decision of Lady Moon finds, and that is what is said in the White Book. I've gone past my time.
No, I don't think you have. So you say, in relation to CPR 11, you say you don't accept that that relates to...
You cannot identify assistance which a foreign trustee might ask the court to provide generically in the future, and say that that should be something in respect of which service out should not have been granted. That is simply something that one can deal with in the merits. It's not CPR country.
I think the point is it's not just assistance generically. it's assistance in relation to a particular asset that is not in the jurisdiction.
And the reason it's not the proper way of looking at it is that a trustee is entitled to say, I would like this court assisting me in my capacity as trustee with a judgment in Russia to enforce or otherwise give me some form of execution or aid to execution in this country of that judgment through the assistance route, which is it's a totally different jurisdiction once one has got service out. And those are our submissions.
Thank you very much. Good. Right. Well, thank you all very much. You'll be unsurprised to learn that we will be reserving our judgments. You will receive a copy of the draft judgment. That will go to those that are on the list which my clerk has compiled. And the judgment is only to go to those people, save that, of course, for the limited purposes described in the Council of Wales case, you will be able to speak to your respective clients about the outcome in order to take instructions. One of the things that you'll be taking instructions on is the draft order, because when we send you the draft, that's an opportunity for you to correct our typos and our grammar, but it is not an opportunity to re-argue the case. And once you've digested the draft, we would ask you to endeavour to agree an order consequent on our judgments, and it is for that that you may need to take instructions. If an order can't be agreed, we would ask you to get as close as you can to agreeing an order and to produce a draft with the best way of doing it is to have two different colours, red for one side, green for another, identifying what particular parts of the order you seek, and then you can produce very short submissions in favour of the proposals in your colour. It's much the most convenient way of dealing with arguments on the draft order. We would then hope to be able to hand down the draft judgments as proper finalised judgments together with an agreed order, and we will identify a timetable by which all that must happen. There will be no need for you to attend when the judgments are handed down because that is now all done electronically. So thank you all very much. Thank you to all those sitting behind you, and I must say the time has gone much faster than I thought it would. Thank you.
All rise.
Is that because it's always
Almost an apology from Coulson at the end. It's the timetable.
Yeah.
You were
I'm not sure that's you. Some people.
Dan, so much for